This meeting is being recorded.
Okay, so it's being recorded for quality assurance purposes, as they say. But as soon as we've finished, I will stop the recording. So if you want to ask any questions and you don't want those questions to be on the record, then I'm happy just to stop the recording at that point in time. All right. So as I say, social media is becoming a bigger and bigger issue in the workplace. So it's increased dramatically over the last few years, especially for business. And the use of social media by employees during their employment can result in employers being held liable for their conduct of their employees or on social media sites, or having the business's reputation damaged. And we'll see some examples of that as we go through today. I think the important takeaway from today's Lunch and Learn is that you must have a social media policy in place. Doesn't matter whether you're small, large, or in between. There is a need to have a social media policy in place so you can cover employee during and outside of business hours. Employees' conduct on social media can lead to termination of employment and also a possible unfair dismissal claim. And we'll talk about that as well today. And having a social media policy implemented is very important so that all employees are aware of their responsibilities to the employer. So in terms of the social media policy, what is a social media policy? It's a policy that is a document that clearly states the guidelines when using social media that's applicable to the employer's workplace. It has to be clear, informative and reasonable, and it should be robust. So a social media policy that has 2 lines in it is not going to suffice when it comes to compliance. It needs to set out the responsibilities of the employee and covers the responsibility of an employee outside of work hours. It must be agreed to by the employee, or at least acknowledged by the employee, and also forms part of their employment responsibilities. So why is it important to have a social media policy in place? Well, this is probably the primary reason, and this is the first case that I can recall that involved the use of social media outside of employment. So this is one of the first cases that involved Linfox, an employee by the name of Stutzel, who worked for Linfox, who had posted inappropriate comments about their managers. And in fact, there were 2 managers that he posted inappropriate comments about. The employee lodged an unfair dismissal claim with Fair Work Australia, as it was known then, rather than the Fair Work Commission. And it was found by the Fair Work Commission that he had been unfairly dismissed. And the reasons why he was unfairly dismissed was that it centred around the fact that Linfox had little or no social media policy in place and provided no guidance for employees as to their responsibilities on social media. So he was paid compensation for loss of wages during the time that he was dismissed. I think the other important point that arises from that case is that Stutzel himself, as part of his defence, said that he was naive as to the privacy settings on his social media page. And the Fair Work Commission, in its decision, also went on to say that that it noted that if there are any further matters that came before the Commission, then the Commission may not be as lenient as they are in this matter in considering such naivety as being a factor. So in other words, what they were saying is, okay, we accept that some people may have been naive, but as time progresses, people become a little bit more and more aware of their social media platform, whether it's Instagram or Facebook or Twitter or whatever. Then as time goes on, people become a little bit more savvy, then the Commission's unlikely to take such a more lenient approach. So that was the first case, and that was the case of Stutzel and Linfox. Then we had another case in 2014, and Linfox had certainly learned its lesson from the previous proceedings and had implemented a social media policy. This case was the case of Pearson versus Linfox in 2014. And Linfox took action against one of its employees for, amongst other things, refusing to sign the social media policy. So in this case, Pearson was given the social media policy and he refused to sign it or acknowledge it and acknowledge his understanding of the policy. Pearson argued that he did not wish to sign the forms acknowledging the company's social media policy, as it also applies to his outside of work. He then jumped on one of the social media pages, I think it was Facebook, and stated, "As Linfox do not pay me or control my life outside of working hours, they cannot tell me what to do or say outside of work. That is the basic human right on freedom of speech." The matter went before Commissioner David Gregory, who was unswayed by the argument and the policy that the policy impinged on the employee's private life. Commissioner Gregory said, in an employment context, the establishment of a social media policy is clearly a legitimate exercise in acting to protect the reputation and security of a business. So there's the first case. Sorry, it wasn't the first case. There's a case where the Fair Work Commissioner is simply saying, if you have a social media policy in place, then you're not doing the wrong thing. So that was a good outcome so far as Linfox are concerned, as obviously they learnt their lesson and had a social media policy in place by the time this matter involving Pearson came around. The next case, well, this was now a 2013 case before Deputy President Sams. And for those of you in the club industry, you probably know Deputy President Sams because he looked after the club industry for a long time. And for those of you who know Deputy President Sams, he doesn't mince words. And this was a case involving the Credit Corp Group. And the employee had posted comments critical of another organisation on its Facebook page, and then posted sexually inappropriate comments on his own Facebook page. Sams had found that his conduct was a repudiation of his contract of employment, and the comments made in his own time were of no consequence, and was likely he could have been validly dismissed even if Credit Corp had not had a code of conduct in place. Sams went on to say, the applicant is perfectly entitled to hold views about any organisation and to express such views in the public domain, but he's not entitled to do so in a manner which injures his employer's business relationship with that organisation. So they are three of the important cases in terms of social media. And there were some clear lessons to be learnt from that. Obviously, the clear lesson to be learnt is that there is a need for a social media policy because it can protect the employer's reputation and minimise risk. The policy makes sure that the employees are aware of their responsibilities and they don't act outside of those responsibilities. It can regulate the employees' activities on social media and make them think twice before they post. It encourages good judgment on the part of an employee, and it can justify termination of employment if in fact there is a derogatory comment that is made about the employer, or indeed any of the employer's clients as well, which is exactly what happened in the Credit Corp case with Deputy President Sams. So what can the social media policy include? It must include employer expectations and providing clear parameters regarding the use of social media, guidance as to sharing confidential information or posting online comments that may be inappropriate. And I'll deal with that in a moment in terms of a perfect example of that. And it has to have procedures to deal with conflicts and the steps to be taken, as you would normally have with most policies and procedures in your handbooks. You should separate personal and professional use so the employees are aware of the difference between professional and personal social media presence. And employees should assume that in clients and future employers will also read information on their personal accounts. And I often say this to a number of people during my bullying and harassment workshops where we talk about cyberbullying and also talk about the fact that many employers now are using social media pages, whether it's Facebook or Instagram, as a character reference. And so all the stuff that you put onto your social media page can be used by particularly employers as a character reference for them. It should also state who's authorised to post on the company's behalf. The policy should clearly detail who's authorised to use the company's or the club's social media channels. They should consult with the appropriate person in the company before answering any media inquiries. And employees should also be reminded and be mindful of the company's reputation when posting on its behalf, because basically that's what it's all about. People jumping on Facebook or whatever social media platform it might be and damaging or harming the company's reputation. You should use disclaimers. So if an employee mentions your business, they should also include a disclaimer saying their opinions and comments do not necessarily reflect that of the employer or the company or its management. And should also ensure that company time is for company business. So you provide clear boundaries around when employees can access their private social media accounts in the workplace. In other words, it shouldn't be done whilst they're at work. It should either be done outside of work or during lunch or a break. And they should be encouraged to limit their use as well. The policy should also respect copyright. So employees sharing links online should be sure the source of the content that's being shared is reputable, and guard against plagiarism by properly crediting the sources of the material they use. And they also should avoid revealing any personal information. So employees should limit the amount of personal information that they reveal online and ask employees to get permission from other employees, clients or business partners before publishing any names or pictures online. So a couple of points to remember. It is possible that an employee's post will be viewed by more people than it was intended. And I'll give you a perfect example of that. We have a client, which is a club in Toowoomba, where a young man on not the club's social media page, but it was the staff social media page, not sanctioned by management. But he made a comment which was very derogatory and was quite hurtful and hateful. And it was amongst the staff at this club. But the problem was that was then screenshotted and sent to other Facebook pages within the community in Toowoomba. So it wasn't just amongst the staff, it then went across the community generally. So there was a fair amount of damage to be done by that one comment that was being made, which was supposed to be amongst the staff, but it ended up amongst the township of Toowoomba itself. It's got to be properly communicated to all staff, and training may be required to educate employees on their responsibilities. So in other words, we need to do training so that they understand. And also, I think it's good practice and best practice if we're able to properly train staff on all aspects of their staff handbook, not just give them the handbook, tell them to read it and sign it. I think there should be continual training of staff around all aspects, including, of course, your social media policy. The policy should also reference the employer's bullying and harassment and anti-discrimination policy. So there's a clear link to cyberbullying. So in essence, there should be a social media policy, but also within your bullying and harassment policy, you should also have a reference to cyberbullying as well, so that cyberbullying should not occur on emails, social media, Snapchat, and text messages. As always the case, the policy must be reviewed regularly to keep up with the changing nature of social media platforms and networks. And as we all know, social media platforms and networks are changing constantly. There's new ones coming up and surprising us all. And also the way that those particular platforms work, particularly in terms of their privacy, is changing as well. So it needs the policy needs to be reviewed regularly to make sure that we capture any of those changes in terms of social media platforms and networks. So in summary, it's this: employers can still enjoy the advantages of social media while still mitigating against the associated risks. And they should be well drafted and well communicated to all staff. And I think that's clearly the case. Writing a social media policy for employees is a good way to ensure they use the sites appropriately, and there's a clear understanding by all employees as to when and when they can't access social media, whether it's the company social media platform or their own personal social media platform. And employees have a responsibility not to damage the employer's reputation, their brand and reputation, especially through social media, because that's becoming a bigger and bigger issue. And I have to say, there have been a number of cases that we've come across probably in the last 12 months or so, where employees, particularly employees who have been terminated, then jump onto social media and they'll write derogatory comments about the employer and the bosses or the CEOs or management. And in a number of those cases, we've actually been asked by our client to send them a cease and desist letter. In fact, we had one just recently who was subject to a deed of release and then went off and jumped on a social media page and wrote some inappropriate and derogatory comments about that particular employer. And we were able to threaten him with a breach of contract because he breached his deed of release, which of course had a non-disparagement clause in it, and also a confidentiality clause. So it's absolutely vitally important that employees know that they cannot damage the employer's reputation, especially through social media. I think also that's been clearly indicated by the decisions of the Fair Work Commission, particularly the second case with Linfox, and also the Credit Corp case, where Deputy President Sams made it absolutely patently clear that that's the case. And the other important point is the impact of social media is tremendous. And seriously, if you look at workplaces, the impacts on workplaces now, the impact of social media on workplaces is growing significantly. We've had a number of issues that if social media had not been around, then those issues would not exist. So it's becoming a bigger and bigger issue in the workplace. I think the clear takeaways from this today is, one, there must be clear boundaries provided to all employees through the social media policy, and that those boundaries through that social media policy are clearly communicated to all staff. I think that's the clear takeaway from today's Lunch and Learn. All right, I shall stop recording